keep coming back and coming back. Then maybe show them a document and smack them in the face politely of their own document. After a couple times of that, usually they fall in line because they go, that was a really unpleasant experience. I don't want Jay to do that for the next 3 hours.
Welcome back to the jurytrial.com podcast, where we interview some of the best trial lawyers in the country. Today, we have the pleasure of speaking with Jay Vaughn, who is the president of the Kentucky Justice Association. He's recognized as one of the best trucking trial lawyers in the country. He serves on the executive board of the AAJ Trucking Litigation Group. He is one of the few, I think, less than 10 board-certified trucking accident lawyers in the country, and he has so many 7- and 8-figure verdicts, I won't even bother to go through them. Most of you probably recognize him for his $74 million wrongful death trucking verdict. Jay, it's a pleasure having you.
Hey, Mike. Hey, Bob. Yeah, thank you for having me on. I appreciate the intro. I was president of KJA, Kentucky Justice Association, back in 2024. So I'm now immediate past president, which is a great role to be in because I'm no longer on the executive committee chatter list, which is fantastic. So that's really good. And anytime that verdict gets brought up, I always want to, give just due where it's deserved. My law partner, Ron Johnson, was lead on that case. I helped him work it up and try it, but he was definitely lead on that. And it was a road construction crash case where a mother was killed. We represented the 3 kids who saw their mom die. And it involved a former commercial motor vehicle that was a guy was using for personal use that was uninsured. And it led us to investigate and realize there was a road edge drop-off case against the contractor that had recently repaved the road and left it in just an ultra hazardous condition that's caused the truck to lose control and kill our client's mother. So, but yeah, and then you mentioned I'd love to at some point talk about the board certification. I was one of the first 10 board certified truck lawyers in the country. We're up to quite a bit now, but it came out in 2018, and happy to talk about that process and why I did it and what it means for lawyers considering doing trucking cases. But yeah, just excited to be here. I love talking about all this stuff.
Yeah, well, let's get into it. I mean, obviously that's where you are today, but I'm always interested in hearing the journey and hearing how you got to where you are. So kind of walk us through your path to being a trial lawyer and finding I don't want to say necessarily your niche in trucking litigation, but how did you get here? What was your path?
I'm glad you asked that because I think it's a great story. I love telling the story of really how it happened. So I grew up in Northern Kentucky, right near Cincinnati, and ended up going to college at Murray State University down Murray, Kentucky. And I'm down there and I'm a double major in math and computer science because I was good at math and computer programming in high school. So I'm sitting there, my 3rd semester at college. It's 8 a.m. I was in a fraternity. I'm a Lambda Chi Alpha. I was hungover, sitting in Calculus 3. I'll never forget it. And the professor comes in. He'd always go over the homework. And he's like, you don't have any questions about the homework? And I'm like getting ready to raise my hand. And a girl in the back raised her hand. She's like, hey, I have a question about 36 part C. And I'm like, 36 part C. I'm like, that's the calculus word problem. I'm like, what about number 1? And like, I had this moment, almost like the Matrix, everything slowed down. And I looked around, I go, what the hell am I doing? Why am I in calculus 3 at 8 a.m.? What am I going to do with this? Like, what am I going to do with a math degree? I'm not going to teach. I'm not going to work for the Department of Defense. And so I had this, and my GPA wasn't great because calculus 1, 2, and 3 were not easy. And my next class is going to be differential equations, which I did not want to take. So I'm like, what am I doing? Well, around the same time, I'm in a public speaking class for like my general education requirement. And I'm in the small group. And in my small group, I give some speech for a grade. And my small group professor said, Jay, you should go out for the forensics team. And me being naive and being educated, in Kentucky public school. I looked at her and go, but I don't want to go into like crime lab stuff because I thought that's what forensics was. She's like, no, forensics is speech and debate. I'm like, oh, my high school we didn't have a speech and debate team. And she's like, yeah, why don't you go out and the big group instructor for public speaking is the coach of the speech and debate team. So I go and talk to her. They throw me into an on-campus debate with people already on the team that was just open to the student body for just entertainment. And I guess I was the sacrificial lamb, and I got annihilated. Didn't know what the hell I was doing. But I'm like, this is interesting. And the guy who was the top like debate student at Murray State, who had like competed competitively nationally, told her get him on the team. The next thing you know, 2 years later, I've been on the team. I get put on scholarship, and I'm doing Lincoln Douglas debate nationally, going to nationals and just fantastic stuff. In that time period, being on the speech team got me interested in the law. So the summer before my junior year of college, I remember I come back in town, I'm looking for a job, and I played a guy I played tennis with. His dad's was friends with another kid's dad who was a lawyer. And I remember through connections, I reach out to them, get in touch with this lawyer. They bring me in, and they interview me for just a summer clerk position. And they're like, we don't know what you'll be doing here. Like we are talking about expanding the office. You'd be sweeping the parking lot. I'm like, well, I used to work construction, so whatever. And he looked at me and he goes, cut the shit, Jay. Do you want to work here? I go, yeah. He goes, okay, you're hired. Whopping, $7 an hour. It was a blue collar firm. They did PI, divorce, criminal law, work comp, and I only worked for the civil guys. I only did personal injury. So I'm 20 years old, and I'm working at this firm, and they had real law clerks from law school. I was the only one in college. And they start taking me to lunch, hand me case files, explaining the law and what negligence is and what a tort is. And they would just give me a file and say, review this, let us know what you think. And I look at police reports and photos, and the firm is known for having a ton of clerks through law school and teaching them. And that's what they did with me. There's a firm in Northern Kentucky called Busol Funk Zebedee. Actually, 2 weeks ago was just their 50th anniversary of forming the firm. So pretty cool thing. But I worked for two lawyers, Andy Busol and Bill Kathman, and every break I had in college, I would come back and clerk. So I didn't go on spring breaks. I just came back and clerked because I thought it was awesome. And then when I applied to law school, I only applied to Salmon P. Chase College of Law at Northern Kentucky University. It's the only law school. It's one of the three, accredited law schools in Kentucky besides, UK and U of L. And I got in because it's the only law school I wanted to go to because I could still work for that firm. So I get accepted. I'm clerking for them. And I remember early in my first semester of law school, which we all know was a nightmare, right? You're a 1L and you're like, am I flunking out? I remember all the classmates are sitting around one day and they're like, well, what do you all want to do? Like, what type of law? And they're all talking about, I want to be a big firm lawyer and working with a firm in Cincinnati and start out making 70, 80, 90,000 a year and doing all this. And I'm like, someone's like, I want to be a criminal lawyer. I want to be a public defender. I'm like, I want to be a plaintiff personal injury lawyer. And everyone starts chuckling and laughing at me, ambulance chaser. I'm like, listen, guys, this is what I want to do. I can help people. I can make a difference. And I was the only one, right? That was like, first day, I'm like, I want to be an injury lawyer, period. And it continued, and I graduated law school, and they hired me out of law school. And I remember we were negotiating my salary, and I came up with a number, and I thought it was a lot of money. Then I'm like, I'd like to make $35,000 starting out, and they're like, done. And that's kind of how it started. That's how I got into it. It was all plain personal injury, except the firm since the early '80s had Progressive as a client. So condition of employment was I also had to do progressive defense, which I hated, but it was good because it gave me that foundation to take depots and be in court. But progressive let us still do plaintiff stuff as long as obviously there wasn't a conflict, right?
How did doing defense work shape your understanding of personal injury and how the other side sees the case? Was it informative? Did it shape the way that you approach cases? That's not, I think, the experience that every plaintiff's lawyer has, understanding both sides.
I mean, although I despise being an insurance defense lawyer for 9 years of my career, it was great in the sense of kind of what I alluded to a moment ago. It gave you the foundation of what it is to be a lawyer, because when you're got a defense file, it's already in litigation. So you're already, and most of them are Ohio cases. Ohio has almost like federal court. They have really early on discovery status conferences, but they were in person. I mean, this was pre-Zoom. Every now and then you could do it by phone if you're running late, but you had to like drive to court, walk in, go through security, and like wait to be called. And usually you deal with like the law clerk or the civil bailiff. Rarely would you see the judge. But you're always in court. So it was good that you're always used to that setting, but you're also always sitting discovery, filing motions, deposing plaintiffs. I think in the 9 years I did it, I think literally one case ever went to trial. And my partner, Bill Kathman, who had the client forever, he tried it. I didn't have to try it, so I never tried a case as a defense lawyer. But on the non-practice, like the actual litigation side, dealing with the adjusters, their procedures, and you could see over time how Progressive started to tighten the defense lawyers on billing and online submit your bills. They would audit, they would cut your time, and the rates were like insanely low. Like, I mean, it was embarrassing how low the rates were. So you got to see that inner working and how the adjusters, some of them would just be stuck on an issue and they couldn't get past it, or they had disdain for a certain plaintiff lawyer or a certain firm, and it would affect the value they'd put on. You'd see some that would have a case, some of these cases are, at one point in Ohio, the minimum limits were $12,500 before it jumped to 25. So if it was a 12.5 policy limit case, they're offering 3,500 and then 3,750 and then 3,900, and their authority is the limits. So we would get the file and we would look at it as a plaintiff lawyer, and we look at them going, what's the impediment to settlement here? Like, well, they're at 9 and they won't move, and we're at 6. What's your authority? 8,500. Offer the 8,500. Like, what are you doing? You're going to pay us more than that? And they would finally listen to us and not all the time. The other thing I learned was, this is good for people to hear, how many really bad plaintiff lawyers there are. Really, really, really bad ones who did not know how to work up a case, who didn't understand liens, who didn't understand causation, who literally, because Ohio has like court-sponsored mediation that's free. Most court mediators weren't great, but it was a free service. So the insurance companies want to do the court mediation because it didn't cost them anything. There would be lawyers literally that we'd show up at mediation. They're like, hey, can you give us 15, 20 minutes? This is the first time I've met my client. Like literally at mediation. We had some where we would just say, hey, we need the bills. We need the bills to evaluate. And the plaintiff lawyer would say, you have a signed authorization, you can get the bills. It's like, well, it's not our job to prove your case. So I would just see how not to work up a case. I would see all the missteps, and I would see how much money they left on the table that the adjusters would have tendered limits had the plaintiff lawyer just done their job. So I always had the mindset of, no matter what you feel like about an adjuster, no matter what, if you think they're being an asshole or they're acting in bad faith, they have 200 or 300 files. They have bosses and they have levels and they have procedures. And if you hit them with a number and you don't give them the information to support it, they can't get the number. It ain't their fault. So it was always, I did a presentation years ago about how to just handle and resolve an injury case. And one of my categories was water your files, always touch them, but also give the adjuster information, like use them as your friend, make their job easy. And doesn't mean you have to like them, but send them all the bills and the records. I would always say, listen, your client was never born the day of a crash. They all have a history. So get as far back records as you can, 5 years, 10 years, 20 years, 30 years, whatever you can get your eyes on it first pre-suit before an adjuster or defense lawyer sees it in litigation. And when the really good lawyers would say, here's the records, here's the bills, here's the wage laws, here's the tax returns, here's the previous tax returns, here's a statement from the employer, here's 10 years of family doctor records, here's, they saw a Cairo before, but 8 years ago, here's those Cairo records. You look at it and you go, okay, And then those were the lawyers that the adjusters would grade. And we would do reports and say, listen, you know what? Mike Karp's on this case. He's an A-plus lawyer. So the limits here are 50, and he's got 30 in bills and a surgical recommendation. Do you really want to mess with him or just pay the 50? We have these other 20 files that we will save so much money in the policy because these lawyers won't work it up and they won't try it. They will refuse to try a case. Mike will. And do you want to get popped on this? And that would be the discussion. So they would know the lawyers that were the ones they didn't want to mess with and the ones that we know we'd have to file 3 or 4 motions to compel, and whatever we told them the last best final offer was, they would take. We learned that.
So Jay, I had a question going back to what you mentioned about insurance companies paying more, to the lawyer to defend the case, and it's even worse. That I guess, in our practice, we see that, and I'm curious from your point of view, is that, I guess, from your experience, a tactic that the insurance companies use, or incompetence of the adjuster, or more with the plaintiff's lawyer just not doing what they need to do to get it, or a combination? What's really going on?
Mainly door number 3. It was a failure of the plaintiff lawyer. Because, and again, all I can speak to is progressive, and only up in, like I said, I stopped doing progressive defense around 2011. But at least up to that point, they had when you got a defense referral, they had, and at the time, usually the same adjuster pre-suit would be the same adjuster in litigation. I think eventually that changed. But when I dealt with it, there would be a little we'd get a referral, and the referral, the adjuster would have to send us answer these questions. And one of it was, what's the impediment to settlement? Why was suit filed? And some could be statute was approaching. Got it. Some could be plaintiff is still treating, plaintiff lawyer wasn't ready to make a demand, or surgeries next week, all that. But most of it was, we're just too far apart. They're wanting too much money. So Bill and I would look at, and we'd review the bills, the records, the demand, the police report, the photos, whatever we had before, while we're at least dictating, we back in dictation, right? We prepare the answer to at least get the answer filed. And if it was a clear liability dispute, that's a different animal. But when it's a clear liability rear ender or whatever, we look at it and we go, okay, range value of this is probably 15 to 22.5, and the plaintiff lawyer is at 18, and you're at 11, and your authority's 15. Here's our estimate for us on our hourly rate for drafting the answer, sending discovery, filing a potential motion to compel, preparing for the plaintiff depo, taking the plaintiff depo, getting things together for the IME, setting, paying for the IME, and cost of mediation, up until that point, and going to a couple case management conferences, here's our estimate of, it's $5,000 to $8,000 over the next 6 to 8 months. You put up another $4,000, the case will settle. So we'll take it, but this just doesn't make business sense.
Right.
And most of the time they listen to us. Sometimes they dig in their heels because of different personal issues, but most time they listen to us. Let's make a call. And we call the lawyer, say, hey, got this. Hey, Jay, what's going on? You're at 19, they're at 11. They're too low. I totally get it. I can get you 14 or 15 on this. If you can get me 15, we can get it done. So hold on, call back. 15 settles it. Can I offer him 15? Yeah. And now we have the case for an hour or 2 hours versus 6 months. Cost us money, but progressive, we had at any given time 75 to 80 open files. It took up 75 to 80% of our time, but only 15, 20% of our revenue. Because we had fantastic plaintiff cases. And our other partner, Andy Busall, never did progressive defense. He's a past president of the trial lawyers and trial lawyer of the year. And we got really good cases. So, it was they wouldn't give up progressive, but it was more time than it was worth. So when we would get a file closed quick, the adjuster would look good because they saved defense costs. We'd be happy because it'd be a closed file. and could move on to a plaintiff case where we make money.
Well, maybe that's a good segue into, one of the other topics we wanted to talk about is how do you take a firm from something like a pre-lit primarily or someone doing progressive defense to what you've done, which is to build out, a firm that can do trials and get awesome results. Like walk us through how that happened.
I think it comes down to when you're doing PI, and especially more of the bread and butter car wreck PI volume stuff. I mean, you're just on a never-ending hamster wheel, and you're just putting out fires, and you try to get your systems, but it's just one thing after another. And I think most of us don't take the time to just sit and think of what do we want to do, how long do we want to do it, what should it look like, who do we know locally, regionally, nationally that has a practice that is attractive to me. I'd like to do that type of stuff. And if you're only local in your state or your little regional area and you're not exposed other than what you see in social media, but you're not really going to conferences nationally and really talking to lawyers, you may not know that answer. Luckily when I was young, my two mentors made me join CATA, which it used to be called Kentucky Academy of Trial Attorneys, then Kentucky Justice Association. The same time when ATLA changed it from ATLA to AAJ, and made me join AAJ. And then started not just going to conferences, but at least on the Kentucky side, I was being asked pretty early on to speak. Initially, you got to pay your dues. So you initially speak on subrogation, you speak on, like that stuff. But eventually, you're up there talking, and then going to national conferences, meeting lawyers, and listening to them, and then going to the litigation groups and joining litigation groups, like that. That exposes you to ideas, and you see what people are doing, and that kind of shaped to where, like, listen, I want to start doing higher end PI cases. Initially, it was nursing home litigation. So about 7 years of my practice, over 50% of my cases were nursing home. Wow. And love the elderly, but I had to get out of it. I couldn't do it anymore. It was too rough. It was depressing. It was hard. I think I was a decent nursing home lawyer. I wasn't a great nursing home lawyer. I mean, I'm past chair of the nursing home litigation group for AAJ because I like to get involved and do that stuff. But there were so many better nursing home lawyers than me, and it's a tough field. Tons of depots and medicine and arbitration motions and all that stuff. And it wasn't my cup of tea once I really got into it. And around the same time, I leave the first firm at another firm where I'm back at now, but then I leave there and I go to Morgan and I move to Louisville to run the office in Louisville. And they give me the option, do you want to be in charge of nursing home for Kentucky or trucking? And I remember I looked at it was Mike Morgan. I looked at Mike, said, I love the elderly. I'll do trucking. and I decided at that point, I was starting to get more trucking cases, but I'm like, I want to be a trucking lawyer. That's what I want to do. And so I did that. I was there for 4 years and I left and I came back to where I'm at now with my partners, Penny, Hendy, and Ron Johnson. Been back since 2018, but it forced me to just focus on truck stuff. So I attended more seminars. I'd reached out to more lawyers. I have dear friends in the trucking world that helped me along. Joe Camerlingo, Joe Freed, Ed Saramboli, Eric Penn, Pete Kessner, Matt Wright. I mean, there's a whole handful that really have helped along the way. But it's you got to dip your toes in, and you got to go to some seminars and volunteer for a committee and volunteer to do something. And eventually you get asked to speak. And I think ultimately the way that most of us get that recognition is you're seen as an expert in that field by your peers. And I remember Joe Freed told me that years and years ago. The way you become an expert is to stand up and talk about something, and people think you're an expert on it, And so I started getting my foot in the door to speak on trucking topics, initially deposing a truck driver, inspecting a scene. And that led to me being recognized, more cases, more referrals, people calling for advice, like all of that. And I think that's what you have to do is to answer your question,
Very
Bob, is to figure out what path do you want. You want to be a volume lawyer? Awesome. You just want to do products. You just want to do trucking. You want a mixture. Like, what is it? You have a threshold of value. And then decide, okay, write down what are the steps I need to do to get there. Reach out to people you look up to mentor you or give you advice on it. And then just start doing it. And when I got to the level of a certain value I would handle and a certain caseload I wanted to keep, I started saying no. That was hard. If you want a niche boutique practice, you have to learn to say no to friends and referral sources. And do it politely, but say, I appreciate it, but that doesn't meet my criteria right now. Like right now, I have 13 cases. My sweet spot is 10 to 15. And I know how I work cases. That's my sweet spot. But to get there took a while. And to manage the anxiety and the fear of saying no to a case, like it took me years to get there. And then I would take cases because I had that fear. And I would accept it out of fear. And then I'd be stuck with a case, honestly, that was shitty. And or I couldn't win, or the value was so low and it was expensive. So now I'm better and more confident with, you know what, Mike, I really appreciate you calling me on that. I think it's a pretty good case. It's just not something my firm would handle right now. Here's two lawyers I think are great. Let me introduce you by text or by email. But I really appreciate you keeping in mind. And I've actually gotten better responses from that to where now they know, oh, when I get a really big one, I'm going to call Jay. And it happens.
I'm curious because, I think the general path that a lot of trial lawyers take is they start sort of as a pre-litigation attorney, trading numbers on the phone with adjusters. Then they get some experience being a litigator, doing depositions, discovery, and eventually they make their way to the courtroom. And for me, that was kind of my path. And after I got into the courtroom and was exposed to these different methodologies, whether it's depositions or trial or speed trial, or even, something as classic as like a reptile opening, it really changed the way that I looked at cases altogether. Was there a certain moment, a certain case, a certain time in your journey as a trial lawyer where you started to see the whole system differently?
I can remember cases along the way that, well, a couple of things. I remember cases along the way that I remember working my butt off, getting a really, really good result. And it came out of determination and hard work and just not listening to the noise of the defense saying there's no case and what are you doing and all that. Right. And so that's just, I could, rattle off 50 cases that hit. But one of the first big ones that really resonated with me was one of the last trucking cases I handled when I was with Morgan & Morgan. It was a really bad crash from a guy that lived in Florida. The crash was in Ohio, young guy, and it was a horrific crash on camera. And I remember I flew out to Pittsburgh. We was at the hospital, met with him and his wife, and ultimately the defense lawyer that got put on the case is a nationally known defense lawyer. And wonderful guy. I mean, I consider him a friend now. And we worked that case up and never filed suit. He asked to come see my client. He flew down to Shepherd Center in Atlanta. I met him there. I let him interview my client, interview the wife. And he's like, we're going to get this thing done. And we exchanged information. We did our own informal pre-suit discovery. And he's like, there's no need to take the gloves off and file suit and litigate. Like, I get it. And basically, because I was nice and polite and I'm not a pound on the table screaming lawyer, and I've never been that way. I don't threaten. I don't send shitty emails and sarcasm and all that. I'm like, here's what I need. I'm like, how do I know there's not more than their tower was 10? How do you know there's not more than 10? He's like, how about we set a call up with their insurance broker who's secured and helped them get insurance policies for the last 20 years. Like, that'd be great. We jump on the conference call with the insurance agent broker for the truck company. And he walks me through all the policies. These are all the policies they've ever had. This is it. I'm like, okay. Like, I don't think the guy's sitting there lying to me. And then we finally work it out, and they tender it was my first 8-figure settlement, and they tender the policy pre-suit. We get everything worked out. We do settlement, investment, and annuities and trust for the client, and we deal with liens, and we get obviously a nice fee out of it. And obviously it was a big number, right? It's a big milestone to hit. I think I have it here. Yeah, I remember Phil Miller. I'm friends with Phil Miller in Nashville, trial consultant, and I teach Depot College with him. And I remember he had a thing where he would mail people every year. He mails some gimmick, and Phil mailed everyone a baseball, and the note said, "Write down your goal for this year." And I remember I got this May 18th to 17. I signed it. And I wrote down. I'll hold my client's name out of it, but I wrote down $10 million on the baseball and my client's name above it before the case settled. And I've always kept this, like, just something to keep in mind. But to see the good you can do out of it, to see that despite contentious stuff, you can work with opposing counsel in a very collegial way when they realize what the right thing to do is. So that case taught me how I approach big cases. And I do it with smaller ones, but the way now most of my cases are all larger, and I approach it the same way. And sometimes defense counsel doesn't bite, and it's totally fine. They got their playbook, but I'm like, hey, listen, here's my letter of rep. Here's my preservation layer. I no longer send the 5-8 page insane spoliation letter. I customize it every case. Mine's like 2 pages, and I go, and then my email to them is, here's my spoliation layer, but there's really only 5 things I need pre-suit. Or 6 things. This is all I need. Don't send me your policy procedure pre-suit. But I need a couple things just to evaluate. And in exchange, I'll get whatever you want, I'll give you. And I'll give them photos of the family. I'll give them past records. Like, I don't care. You're going to get it in discovery anyway. And more times than not, that approach, they appreciate, because I'm not just pounding on the table and said, give me 10 years of all this. I'm like, I need 48 hours of this. I need 1 month of this. I need whatever. And, but it kind of softens the tone, and we just have a discussion, and they're like, listen, I can get this stuff in litigation, but I'm not looking to file right now. Some cases we have to, but like, can we at least see if we can work together? And the ones that do, honestly, are the cases that we've resolved for substantial amounts, sometimes without having to file suit. Sometimes we file suit just so we get subpoena power, but we go to a mediation, we exchange some discovery. Those are the lawyers I like to work with. And the ones that on the front end just aren't used to the nice, open, all cards on the table approach, then I know it's just going to be a long litigation. And that's fine. I mean, that's fine. But that's what I've learned is I try to just, hey, let's just put aside the V and let's just talk. And what can we exchange?
Listening to you, I think what resonated for me is the people who are those nasty kind of litigation people, I think lack confidence. And when you're just laying your cards on the table and you're nice, it just shows them, like, look, I'm just telling you what it is. If you want to take what I'm offering, fine. If not, we'll see you in court. Like, that just comes from a place of confidence. And Michael and I always talk, the lawyers that we want to go against in the courtroom are those kind of the nasty lawyers, because that drives the case value and that drives the jury getting upset. The last person I want to try a case with is someone who's like really nice and going to go in there and accept some responsibility and just drive the case value down is really what happens.
There are some absolutely just awful, aggressive, overly aggressive, unreasonable plaintiff lawyers out there and colleagues. And I've co-counseled cases with some of them. Like it's just they believe that you have to scorch earth and scream and fight and insult. And I'm like, life's too short. Like, we do this. This is our living. It's a great living. We can make a big difference and we can have a nice lifestyle. But like, in the end, I really don't care about this. I love it. I do, but I want to go home. I want to play tennis. I want to have a bourbon. I want to watch a show. I want to just turn my brain off. And I just don't want to just, yeah. So yeah, a lot of that goes on. And, I know that there was a case I resolved recently this year, and my settlement demand letter um, to the defense lawyer, which also I then gave to the mediator. And the mediator talked about this at a seminar the other day. She's fantastic. She's in Dallas. Her name's Cedar Abity. She's a great trucking mediator. And but I sent the defense like my settlement demand letter. I told the defense lawyers like I'm not going to write up liability. I'm going to tell you about my clients. And my client's mother was killed, and she had a very checkered past. And my entire demand letter was the absolute truth about their family history and how social child services took the kids away, and mom was in jail, and mom, drugs and lost jobs, and kid has this and that. And I was like, but here's the rebound of the life. Here's how they were trying to rebuild it. Here's steps they were taking. Mom was taking, like, and it's still their mom, and they're still minors under 18. And so, but yeah, like not running from this at all. This is the story and this is the truth. And here it is. And they weren't expecting that. And even in private caucus, like the message got out, like he owned it all. He wasn't painting some false rosy picture. The defense lawyer finally told me, he's like, Jay, I really appreciate that. Like, he goes, still, that's probably your best version of it. I said, it is. And I said, and there's probably more that we even don't know that we would find litigation, but there ain't, it's not the family leave the beaver, right? Like it's not some wholesome, nice family. Like there are many problems, but you still killed their mom.
Yeah. With high transparency, high integrity, seeming to be core values that you have and how you approach your cases, how you approach your practice, how does that translate over to depositions, if at all? I'm curious, at the Depo College, if those values sort of make its way into how you approach depositions.
I mean, I guess it's cliche to where you say, listen, every case is different, every depo is different. But I mean, it is true. Like I'll sit there and, I spend a long time preparing for depo. I don't just prep the day before. I block off prep on my calendar weeks in advance. I mean, there's a depo I took in March. I literally prepared for that depo for 6 weeks. That's all I did. And it was a 30B6 in an Amazon case, and I'm like, I really need to get this right. But not like 8 hours. Like I'd work, and again with my schedule and my caseload, like I can work for 2-3 hours, be hyper focused, and then be like, you know what, I'm going to take the rest day off. And I'll come back tomorrow and I'll work another couple hours. And I'll come, and then that's how I like to do it. I know that everyone doesn't have that luxury, but whatever it is, block. You have to block. I preach this and teach this all the time. You have to block the time off in your calendar for prep. If you say I'm going to prep on Tuesday for this depo, and it's not blocked off in your calendar, new calls, new client meetings, emails coming in, phone calls, and you're if you get the prep, you're not really tuned in, you're not really focused. So I treat it like a trial, like I'm in court, like an actual depo. And if it's blocked off, that's my time. And I will then look at what's my goal in this depo. What do I really want to get out of it? What do I hope to get out of it? What do I think there's no way I can get? And then I'll draft the order of it based on my goal and my strategy and decide. And some cases I'll hit with basics and foundations and training and rules and eventually get to the crash. Other times I'm like, tell me what you remember about the crash. And I do that strategically because I want to get them to say what they did and what they would have done under certain conditions, and then later hit them with what the standards of the rules should be, or if they're trained that way, what they would have done had they known that, and then maybe hit them with some strong evidence that truly contradicts what they say, a photo, a download of the electronic control module, like whatever it may be. And there was one where a crash I got brought into in Ohio, lovely lady, T-bone, a fuel truck ran a red light in the rain and T-boned her, really bad injuries, brain injury. But I remember I have this whole plan, and I go in, and the truck driver is a younger guy, nice looking dude, very polite. And I remember I'm sitting down. He's right here to my left. It's one of the few depots since COVID I did in person, and I just had this feeling like I think this guy's going to cry. I'm like I I need to calm it down. So I just started the depot, and actually my buddy Ed Ciamboli gave me this idea, and Ed's one of my best friends in the whole world. Ed said, I was talking about my process. He goes, here's what I would do. Just start out by saying, hey, I just want to make sure we're on the same page before we go any further. You agree that you caused this crash and injured my client, and you accept whatever you caused, right? So I phrased it something like that. I said, hey, before we go any further, like making sure, I think I know what you're going to say, but you're at fault. You caused this crash. Because, yeah. And you injured my client. Yeah. And you agree you're responsible for any of the harm you caused it, right? He goes, yeah. Anything she did wrong? Nope. I said, great. Then I sat there, ignored my outline was still there to make sure I covered stuff. I skipped half of what I was going to do. And I just sat and had a conversation with the guy. And he talked about how well trained the company made him, that he just saw the yellow light and he made a decision. He chose to gun it instead of slow down, which is the wrong thing. He talked about the jaws of life and the noise and her getting pulled out of the car and how awful it was to see. He talked about that, he got fired because of the crash, that he really questioned never driving a truck again. He's at another company now, but it's doing something a little different, but like he thinks about it every day. He hopes she's okay. And then the next step is the owner of the company, like the owner. Nicest guy in the world. Same thing at the beginning, fell on the sword. Our fault, our driver's fault. We're responsible for whatever he did. She did nothing wrong. We're sorry this happened. We feel that we trained him well. We gave him double the amount of training we've ever given anyone because we want him to succeed. The most detailed train notes I've ever seen in my life. I've actually lectured on this, and the owner clip I played is I've never seen notes this detailed either, Jay. We did extra for this guy because he'd never hauled fuel before. We wouldn't have put him on the road, and the guy that trained him was a former sheriff. And so law enforcement, very strict, and said, and afterwards you fired him. He said, yeah. I said, why? I said, we couldn't have anyone like that in our company anymore. So I sat there and I go, and we leave the depots. I go to the next conference room, and defense lawyer, he comes in with me. We sit down. I said, let's get this mediation set. I go, under Ohio law, I go, obviously you're at fault. Your client's at fault. My client did nothing wrong. But after all this, there's no direct negligence claim. There's no negligent hiring or training or that's out. There's no reckless conduct. There's no punitive damages. So we just need to negotiate what's the value of a brain injury case in Ohio, which is tough because of the caps and the wording of the caps in Ohio, and whether a brain injury qualifies for a cap exception to where you have no cap. That was the debate. But I said, here's what's worth. And they were at high six figures pre-suit. So it wasn't enough. When we go to mediation, we get over seven figures. But it was a calm, but I knew at that point, I don't have bad conduct. And I remember, I never forget, literally the day after the depot, no lie, I had a call with Robert Collins down in Texas, because Robert and I were talking. I was getting ready to be it's something to deal with the brain injury group for AJ, because he was an officer. He's chair now, and I was either incoming chair before, and he was vice chair. But doesn't matter. Whatever reason, we had to talk about something. I say, Robert, let me talk about this depot yesterday. And I told him what the driver said, what the owner said. And he goes, holy shit, Jay. He goes, if truck companies and drivers would do that in all of our cases, it would reduce the value by a third to 50%.
Yeah. Well, that's what I was saying before, is that's what you don't, as a plaintiff's lawyer, you don't want that. Yeah. And that just, like you said, shoots the value when they come in and they're like, yeah, I'm at fault. And it takes a lot of the sting out of the case. But yeah, I mean, just goes to show you that you have to be able to kind of pivot with what you have and then recognize it. You can't put, something into, square peg into a round hole. It's just can't do it.
It's funny. I use that analogy all the time. I was really getting ready to say that. It is, we get so pumped up and so worked up about the crash and bad people and bad company and I'm going to annihilate this person. I'm going to kill them in depot. And it's like, I don't want to kill someone in depot. I don't want to be aggressive and me look like the asshole. Like, I want to be nice. I want to be fair. And if we ever play this clip and they hear my voice and the witness's voice, I want it to be that he was being fair and the witness is being unfair. If we look unfair, we lose. We lose. And we fit the stereotypes, right? So we have, like, and I'm an outline person. Like, I've had depots where my outlines are 30, 40 pages. It's not there that I ask it verbatim. It's there. Sometimes I do, but I listen to the witness, and I not just listen to them. I get a feel for their attention, their focus, their personality, where I think I can get them. And there's some witnesses that are just stuck and they're prepped and they're not budging. And there's others that, if I spend a couple hours with this person, I can probably get them from here to here, and I need them here. And if I'm patient with it and I'm polite and I'm courteous and I tell them, that, like, when they say, what do you mean? Or what I think this means is this. I'm like, that was a really good point. Like, that's fair. Let me rephrase it. Like, I like what you said. And I just have a conversation with them. And that's what we teach at Depot College. That's what, like, have a conversation with them, truly tune in, truly listen, and let them take you where they take you. And don't fight and say, well, because I didn't get these 8 points, like, I have to get these. No, you don't. If you get one, you're great. Get the others from someone else. But I think too many times we have that. It's that fear. It's that intensity. It's the, I'd spent all this time prepping. I'm the lawyer, my ego. I'm going to get this witness to do everything. If not, I'm going to beat them into submission. That's not how I practice.
How does your approach to depositions differ from, let's say, a direct or a cross-examination at trial? I know, for me, like, I would start off earlier in my career and I would script every single question, even for a direct or a cross at trial. And I was so afraid to deviate from that outline because I had felt, I had put so many hours of preparation in. I had thought about every different way it could go. And I had decided on, okay, this pathway, this decision tree is the one that's most likely to lead to the admissions that I want to get. And it took me a lot of time to trust myself and give myself permission to, do something similar to what you did in that deposition, which is you went in, you were present, you identified that the witness was emotionally attached to the case, that he probably wasn't going to fight you, that he wasn't going to insert that conflict into the case, and you kind of just ran with it organically in the moment. Where did that come from? Is that something you had to learn over time? Is that something you learned in trial versus in a deposition? I'm curious to hear how that kind of evolved for you.
It definitely was learned, and it evolved over the years. I would hate to look at the depots I took 20 years ago. I'd hate to look at the depots I took 10 years ago. I can remember a particular depot of a truck case I had in federal court here in Kentucky, and it wasn't a huge case. It was a 6-figure case, but it wasn't a huge case. And I remember I went in like, this depot is going to be a slam dunk. It's a 30B6. Like, it's going to be a slam dunk. Like, clearly violated the rules, clearly led to the crash. And defense lawyer was a really crisp tongued defense lawyer and with a condescending tone that had gotten under my skin before. And the owner of the company was a 30B6, and he wasn't having it. He resisted on every place I took him. He disagreed with every assertion I made. I'd show him examples, industry standards. He still disagreed. And I got mad. I lost my cool. And I got real shitty with him. And I raised my voice. I was attacking. And I remember the defense lawyer said, "Hey, Jay, like, can you calm down? Oh, like I don't like you yelling at my client. I remember I paused and took a break, and I'm like, what am I doing? Like that's not me. But I wasn't prepared for it. I thought it would be a walk in the park, and I wasn't prepared emotionally for what would happen if he resisted. And the resisting didn't hurt me. It made him just look unreasonable because there was everything that industry teaches. His driver did the opposite. But I was so focused on getting the yes to my question, getting the agree, that I lost control. Yeah, I remember. I mean, I remember that, and it's like it's one of the few depots I remember taking that I truly, truly not just lost control, like ashamed of myself. Like it just was one of those. It was a learning point. I said, you know what? I'll never do it again. I will never get mad at a witness again. I'll never challenge them. I give them options, and they can agree with me or not. If they agree with me, I'll say why. If they don't, I say why not. And most time in depot, I really don't care what their answer is. I can go and I can prepare for trial, whatever path they choose. And what I've learned is the nicer I am and the calmer I am, they may resist initially, but then when I keep layering stuff and they keep wanting to explain and it depends and give run on answers, and I keep coming back and coming back, then I maybe show them a document and smack them in the face politely of their own document. After a couple times of that, usually they fall in line because they go, that was a really unpleasant experience. I don't want Jay to do that for the next 3 hours. And but if they resist and they're prepped so hard that they just are told to say no, don't agree, totally fine. Like I have no problem with it because I know what I can do with that trial. So as that depot is taking place, my brain is now over here going, at trial, I can have a board, I can get them off the stand and just slam them with document after document after document after photo after whatever it is, and just make them look bad. And at that point, I'll be in control. I can do a more direct, pointed, leading question, even though I lead in depot, but like I can totally different performance, totally different because there I'm doing it for the jury. I'm doing it to say this person's not being fair, because they're not being fair and they're resisting. It's not just why this crash happened, it's why my client was killed. So I just use it for ammo for trial now. And to go to your question, Mike, for a director or across, I think of what does the jury really have to hear for me to win, and and can I take a 4 hour depot or a three? And I'm usually fast on depots. Usually my depots are 2 hours ish, hour and a half, because I cut out. That's the other thing I've learned. I cut out all the BS. I just don't do all the, because frankly I don't care. I don't want to spend all the time and all this stuff. I try to get right to it and move on. And Satch Oliver does a great job teaching that in his book, Depositions or Trial, of like chapters, and just if you get it, move on. Trial, I can take a 2 3 hour depot of a witness and I can turn it into, literally, I can turn into 15 20 questions for cross a trial and be done. Know that this is all I need. Don't be greedy. The act, some yeses or victories for us as lawyers mean nothing to the jury. What does the jury have to hear? Not just to prove we're right, but to get angry, to say this was preventable, this was foreseeable, shame on you, driver or company, for allowing this to happen. What can I do with that? And that's all I care about.
Yeah. So Jay, you talked a lot about the AAJ Depot College and some of the trucking groups, and I know you're also part of Sari's group. I think I've been part of that last couple of years. I think you were a little more active before I joined it, but just for people who are kind of starting out on that path of wanting to become a great trial lawyer, what do you recommend? Clearly, you're pretty big on the AAJ Depot College. What's been your experience, and what do you recommend to people to take them from beginning trials to really being great in the courtroom?
I think whatever your state TLA is, obviously don't just be a member, but you know, um, go to the seminars, try to be on the board, run for the board, get people to sponsor you, to recommend you, be active on the listserv, ask other people that you look up to. How can I get more involved? Volunteer for committees, volunteer to write an article if you all do a monthly newsletter or magazine, volunteer to speak on something. Just get active, and don't be a passive, non-contributing member. Contribute not just your time and your knowledge, but even if it comes up with giving monthly to the organization, helping out with political contributions, give your money to, like, give your whole self, and it will come back in spades. Nationally, AAJ, find what practice areas you want. Like, I'm pretty active in I'm past chair of the traumatic brain injury litigation group. I'm on the board for the trucking litigation group. And those are my two main groups in AAJ. Outside of that's ATAA, the Academy of Truck Accident Attorneys. I'm on the board of regents there, and they do a symposium every year, and it's in September this year in Denver, and it's the largest plaintiff trucking conference in America, and there'll be 500, 600 lawyers there. It's a 3-day conference, everything you could ever imagine about trucking. Plus, I have a paralegal track. You can send your paralegal. Like, it's fantastic. But that stuff, and then I know there's other programs out there like, Trial Lawyers University and TLU, do their programs, and they have a different exposure of lawyers, more West Coast than we see through AAJ, and you learn stuff, and there's great programming, great content, and then side stuff like the AAJ Trucking Litigation Group. Every other year does a trucking trial college. We just did it in Dallas this year. Next year will be a new lawyers boot camp. The year after will be a trial college. After that, new lawyers boot camp. So we rotate. ATAA does the same thing. And those are, 2-3 day, smaller 60-person, 80-person conferences where you're practicing skills in workshops. AAJ does the depot college. That's in January. TLU for the first time, a lot of us from AAJ are doing a TLU advanced deposition college in February back at Pasea, and teaching those skills. Like, that's the best, is not just lecture stuff, but where you get skill work. And that's where you can be vulnerable, and you have to be. And don't come in with preconceived notions, this is how I do it. Go in to get better. I mean, I've been practicing 24 years, and guess what? I can get better. There's more I can do. And then other stuff, like I said, Sorry Delamont, like you said, Sorry does a really good job. And I mean, like I started her class during COVID called Path to Mastery. I was in the first group she did that with, and it was by Zoom, but it was great. And it really taught me stuff about myself, and I needed it at the time, with mindset and personal stuff. It also helped me grow as a lawyer and learn better ways to pick juries. And, Sorry, before I even joined the group, Sorry, I want to at least give her a plug for this. She taught me something that us lawyers never do. I remember it was the fall of 19, and I recently lost a trial that at the time thought was the best case I ever tried in my career, and lost, and got reversed on the appeal. Judge put in evidence he shouldn't have, and we settled after it. I won the appeal, but at the time I was devastated. And I remember I was on one of her Facebook Live things, and I made a comment, and then she messaged me, "What's your number?" And she called me. We started talking and telling her about this trial. And she's like, what you lawyers do, you hold on to these trials, wins and losses, thinking it had something to do with you. And yeah, you facilitate it, but it's the jury's decision. It's a reflection on what they feel about the evidence and your client. That's it. And you take these losses so personal, and and she goes, a loss is a loss. It sucks. I get it. But you need to move on from it. Just like if we lose a loved one, like, we have to grieve. You need to mourn your loss. And I remember she got me on the phone, made me lay on the ground. She laid there with me and had me mourn my loss, had me in tears. Like, I'm on the floor with this woman I've never met on speakerphone, crying my eyes out. And it's so funny now when I think about it, because I'm like, I don't know who this is. And I mourned that loss. And she's like, what's it feel like? What emotions? What are the senses? And we went through it for 15, 20 minutes. And God, I felt better after that. Felt so much better. And then I went to her class, and so she's, my spirit animal. She's always hold a close place in my heart. And we have to do stuff like that too. We have to branch out. and expose ourselves to different things for sure.
You and Bob would know a lot more than me, but just in my experience over the years, the plaintiff's bar has evolved a lot, especially since I would say 2020, 2021. I'm curious, as you look into the future, what excites you most about what's changing in the plaintiff's bar and where we're going?
I think it's there's a couple things. One, I think we're getting more options and variety of groups to attend things for, and that's good. Not something's not everyone's cup of tea, right? So I think the options variety is good. And I get some of the programs are for profit and it affects the TLAs and AAJ, and I get that. But when the programming is good, the program is good. And when it's in a fun city, it's in a fun city. I'm sorry, right? And schedules, like we can get to stuff easier. Obviously, the Zoom stuff and like we're doing the podcast and like the remote stuff is big. I think that we've always, as a plaintiff bar, has always shared. I think I think getting into sharing the more intimate details of how we won a case, more importantly, why we lost a case, what are some strategies, some more high level stuff. Um, and I think that's what's really good about it. Some of the AAJ litigation groups is, we'll have members only programs where there's no CLE, there's, it's not recorded. You have to physically be there for a day and a half and pay the money to go, and it's shorter 15-minute presentations of really quick hitters of nothing but takeaways, but really high level stuff, really high stuff of the trade that we don't want on a regular 1 hour seminar somewhere recorded. um, it's learning to specialize into that stuff. I think is a big deal. But I think we've always done that as a playing for. I think we're just getting more sophisticated about it. um, but strengths in numbers, sharing orders, sharing motions, like something that like ATA's done. So back in 2021, Matt Wright out of Nashville and I and Joe Camerlingo from Jacksonville, Florida, we started our own private little grassroots, our own litigation group, not affiliated with any organization dealing with Amazon, and ran it like as a Google group and had a private email address and had a vetting system and a joint prosecution agreement. And we got it went from 3 lawyers to like 200 lawyers. It got too big for me to manage. I was the administrator to approve people, you know, and so we struck a deal with ATA and rolled it into ATA. And ATA now has an Amazon litigation subgroup that's free if you're an ATA member, but you have to have an active Amazon case, sign a joint prosecution agreement. We have our own listserv, but it's fantastic. Like those types of things are I think, a new wave of just lawyers with these types of cases. And it's nice because it's not just, oh, you have an Amazon case. If you bring me in as co-counsel, I'll share stuff with you. It's not that vibe. Although to be honest, and I say this without any hesitation, you know, whether it's an Amazon case, a FedEx case, CH Robinson, JB Hunt, Prime, whatever it may be, if you have a significant case, significant to me is example, if you have a case involving Amazon semi or an Amazon van, and you think your case is worth 500,000 to $1 million, don't sue them, because the company or the van, the DSP or the relay carrier will have $1 million policy. If you think your case is 1.25, don't sue them to think you're going to threaten or force Amazon into paying you $250,000. Like, you need to have a significant 7-figure case or 8-figure case or more to go against these Goliaths, because they really are. I mean, money is nothing to them. Best defense firms, scorched earth, like that's their goal. So if you have one of those cases and you've never handled and litigated an Amazon relay case, then you know what? You need to bring someone in that does it, to understand it. Like whether it's a straight referral, a co-counsel, whether it's FedEx, whoever it may be, you need to start associating and not just think, well, I'm a good lawyer, I can do this, because there's so much product knowledge that's impossible for you to understand. And there's so much you'll miss. And then you do one, and maybe after that you can do it on your own. But it's not just leaving money on the table. You're hurting your client. And I think too many lawyers And listen, we have a great plaintiff bar in every state, great lawyers that have gotten great results, but we have an ego and an arrogance that think we can always do it. And guess what? I have no problem co-counseling with someone, sharing in the result, but like, hey, I think you're better at this piece. Like, let's do this together. I think that needs to happen more, because it's just going to make us stronger as a whole. Because the last thing we want on some of these big companies is a bad order in Wisconsin and a bad order in Florida, and from lawyers that aren't experienced and are getting summary judgment granted against them because they didn't know that there's these 5 documents for this one company that if you knew what to get and you got it, proves your entire case.
Yeah. I think that's fantastic advice. For anybody who's listening who wants to learn more about the Amazon litigation group, the Depot College, or just wants to reach out to you, maybe they have a trucking case, what's the best way to get a hold of you?
Best is, I'm a cell phone guy, especially text. My cell phone's 859-468-7031. You can always email me. It's a letter J and then my last name Vaughn at justicestartshere.com. But you can find my profile online. But that just shoot me a text, give me a call. I talk to lawyers all the time about stuff, and I've had lawyers that have called me on Amazon stuff, and it's a case that's worth, $300,000-$400,000. Like, should I sue Amazon? Like, hell no, you shouldn't. Like, why do you want another defense firm in your case when you're never going to get their layer? Like, just don't do it. Just because you can, don't. Like, we got to be smart about that. It is back to the square peg round hole. If it's not there, it's okay. One day it will be. Just wait. Be patient. It'll come.
Well, thank you so much, Jay. It was a pleasure having you on. For everyone who's listening, thanks for tuning in.
Thank you all so much for having me. This was fantastic.